I'd like to address this because this particular judgment, in my humble view, does not take into account the arguments that we have actually raised.
That's okay, but with
And
regards
I
to
also have to make the
same
submission that
respondent.
this was an ambush PIL in this particular judgment because we have raised grounds of challenge
Which
under
article?
please, this judgment that has been cited,
Which article not dealt with?
Article 191.
This will amount to office of profit.
Yes, we are actually saying it doesn't fall under the exemption.
Then it is not a cabinet rank.
Milords, if I may say so. I'd like to address this because this particular judgment, in my humble view, does not take into account the arguments that we have actually raised.
That's okay, but with
And
regards
I
to
also have to make the
same
submission that
respondent.
this was an ambush PIL. Can I address Milords? Article 191 has not been dealt with here
Which one?
in this particular judgment because we have raised grounds of challenge
Which
under
article?
please, Milords, this judgment that has been cited,
Which article not dealt with?
Article 191,
Live
which
one.
speaks of the prevention of disqualification with respect to office of profit. In my petition, I have raised
So
arguments.
this will amount to office of profit.
Yes, we are actually saying it doesn't fall under the exemption.
Then it is not a cabinet rank.
Milords, if I may say so, that's what happened. So if I may just make this submission,
Both may not go consistent.
can I just answer this question? What has happened is they have tried to peg these posts under the legislation which enjoys the benefit of Article 191. In addition to that, they've also given them the post of a cabinet minister or equal to the cabinet rank. So one is whether it passes muster on the annals of Article 191. And second, having given them the same treatment as a cabinet minister, there's a second violation under Article 164(1)(a). That's been the argument in my petition. That is not the argument that's been raised here. Firstly, in this case, could my lords kindly come to the judgment? Please, could my lords come to paragraph number 16 of my writ petition on the grounds? My very first argument is violation of Article 191, Office of Profit, because some of the posts that have been specifically extended the benefit under the Prevention of Disqualification Act do not fall within that particular exemption. So allow me to show that. This is my first ground, violation of Article 191, Office of Profit, appointing members of the Legislative Assembly and members of the Legislative Councils as chairpersons of boards and corporations with cabinet rank benefits constitutes holding an office of profit. This makes them ineligible to serve as legislators as per Article 191 of the
Where
Constitution.
you are reading?
Please, minutes.
Reading where?
This is paragraph 16 of the writ petition, page number 17. This is my very first ground of challenge. So the point is, if they say this judgment covers my position, it does not in entirety because there are multiple grounds in my petition.
Paragraph 16.
Paragraph 16 at page number 17, violation of Article 191, Office of Profit. The second ground is Article 164, running in non-compliance.
Law. Let us go slow.
Please.
Read 16. Appointing members. What is this ground? Let us see.
Can I just answer the question? Could my lords take a look at the Prevention of Disqualification Act and Article 191? I'll explain the argument right away. Kindly take a look at Article 191 for a moment.
Yes.
Just give me Article 191. The provision says, does the bench have it? Article 191. Disqualifications for membership. A person shall be disqualified for being chosen as and for being a member of the Legislative Assembly or the Legislative Council of a state. Please see A. If he holds any office of profit under the government of India or the government of any state specified in the first schedule, other than an office declared by the legislature of the state by law, not to disqualify its holder. We are making the submission. So under the second provision, they have the Prevention of Disqualification Act for Karnataka. Therefore, we are saying some of the positions which have been notified for the purposes of exemption don't even attract those provisions, in the sense it is outside the scope of this exemption. So my very first ground is that it directly attracts 191A. I'll show that from the legislation as well as the notifications which have been impugned. And the second ground is, having elevated them to the status of a cabinet minister, or the rank of a cabinet minister, it then triggers the application of 164(1)(a). So the very first ground is Article 191. Can I just show the Prevention of Disqualification Act for a moment for my last consumption? There are only 3 sections in that entire act. It's fairly clear. Could my lords kindly come to the Karnataka Legislature Prevention of Disqualification Act. And then I'll show the impugned notifications to show on the face of it how they violate this. So my lords, the provision would start, so the act starts at page number 3 of this compilation. It has the statement of objects and reasons in the first 2 pages. Then my lords could come to page number 3, which has this act. Does my lords have it? Please, minutes. Kindly see the relevant definitions. Committee compensatory allowance and statutory body. Let me read out committee and statutory body before I come to section 3, because section 3 is the prohibitive provision. Kindly come to section 2A, committee. Committee means any committee, commission, council, board, or any other body of one or more persons, whether statutory or not, set up by the government of India or the government of any state. Then kindly come to the definition of statutory body, Millets, which is 2C. Statutory body means any corporation, board, company, society, or any other body of one or more persons, whether incorporated or not, established, registered, or formed by or under any central law or the law of any state for the time being in force, or exercising powers and functions under any such law. This is the meaning of a statutory body for this act. Kindly come to section 3. Removal of certain disqualifications. My Lord Justice Arun has it. Please, minutes. It is hereby declared that the following offices shall not disqualify and shall be deemed never to have disqualified the holders thereof for being chosen as or for being members of the Karnataka Legislative Assembly or the Karnataka Legislative Council. So only these offices will get the benefit, Millards, for the purposes of disqualification. The office of a deputy.
They are not the offices of profit.
Correct. For the purposes of Article 191, this is the exemption. The second part of Article 191A is being satisfied through this, which is why it says removal of certain disqualifications. The office of a deputy minister, a parliamentary secretary, the leaders of the opposition or government chief whips. Kindly come to the next page, minutes. The offices held in NCC and maintained under NCC or the Territorial Army. Then kindly see BB. The office of a member of the Home Guards. Then kindly come to BBB. The office of a member of a village defense party constituted under so-and-so. Then C, the office of the secretaries of the district development boards constituted by the state government by whatever name called, provided that holders of such office do not hold any other office of profit under the government. Then double C, offices of Adhyaksha and Upadhyaksha of the Zilla Parishads and Pradhana and Upapradhana of Mandal Panchayats constituted under the Karnataka Zilla Parishads Acts. Then kindly come to D, the office of the chairman or member of a committee, provided that the holder of any such office is not in receipt of or entitled to any remuneration other than the compensatory allowance. Now, through multiple amendments, more positions have been added to this. Kindly come to the next page.
Will it not fall in D?
Please, minutes.
The present appointments. will
It
fall-
won't. I just wanted to show that. Some of these cases are actually statutory bodies. So totally, I'll just give the split here.
Chairman and member of committee.
Please, minutes.
Clause D of.
Yes, office of the chairman or a member of a committee.
uh,
It applies to some, it doesn't apply to all the 42 members. So I'll give the split here. I'll just explain this. Totally 42 people are here. Out of them, 8 people directly violate 164(1)(a). They fall within this, in the sense they are exempted by this.
64(1)(a) violation can we now examine in live wake of this?
I'll answer that question. I'll certainly answer the question because every judgment on the subject goes against what's been held here, including the Supreme Court. And there is no substantive examination, if I say so with the deepest of respect. I understand the judgment has come from the predecessor bench. I bow down with respect to that.
You can't make such allegations saying that we have set up the case and got it dismissed at your lordship.
I never
That is
said-
what he's trying to tell.
I'm trying to say something else. I don't know what insinuation is this. I am making a submission on merits. I don't know why are they taking it so personally. I'm still only on the merits of the case, not the content of the petition in the previous case. I don't know why the pins are, pinching them unnecessarily. My submission is this. The judgments are also very clear that substantive examination has to take place with respect to the impact. We have presented a table in our petition in terms of what is the economic impact. Primary reason is if there is already a cabinet post and then you elevate another person to a similar status, then there is a duplication of roles with respect to the same function that is in the teeth of 164(1)(a). None of those examinations have been undertaken. That I'll come to later. Can I just show this for a moment? Under 191 in the first place, because this article has not even been considered. So their entire argument is the entirety of my petition is eclipsed by the judgment of the predecessor bench. I'm saying that is not the case. The argument under 191 has not even been considered, let alone even been raised for that matter. Now, therefore, if my lords were to take a look at this compilation, other than the posts mentioned in the previous section, through amendments, a few more posts have been added. We have checked none of the new positions, at least 30 of those positions, actually satisfy any of the amended positions as well. So totally, out of the 42 people, 30 people directly are in violation of 191. All of them put together are in violation of 164(1)(a) because they have crossed the ceiling of 15%. Let me show the 30 positions and say how they don't fall within.
Because they are
Please.
crossing.
I'm
What
so
did you submit? Because they are,
In the sense, all the 42 people go beyond the 15% limit. Out of the 42 people, 30 people are in violation of even this act. So 40,
Act.
yes. So 42 people hit 164(1)(a), 30 people hit 191, the bar under 191. The state of Karnataka has 224 members in the assembly, out of which, if the 15% bar is applied, the number goes to 33.6. Therefore, only 34 people can be appointed to a cabinet rank post. And the website of the Karnataka government says 33 people are already in that particular position. Through this particular notification, that is the 9 notifications which are under challenge, 42 more people have been added to this. And they've been given emoluments and treatments at par with the cabinet positions already held. Therefore, they certainly trigger the application of 164(1)(a). But in addition to that, serious violation of even the Disqualification Act, which is why, my lords, at the very least, notice is this matter bears issuance of notice, but I leave that to my lord's discretion. That's entirely up to my lords. Let me just show this for a moment. What are the positions in question? Could my lords come to page number 50 of my petition, which has the first notification under challenge. So 34 people came through one notification and one notification each for 8 other people. So totally 9 notifications are under challenge.
so how many respondents are here?
On February 21st, the Karnataka High Court heard a major challenge against the state government's decision to grant cabinet rank status to 42 MLAs and MLCs heading various boards and corporations. Appearing for the petitioner, advocate J. Sai Deepak argued that giving cabinet privileges like official vehicles, higher allowances and minister-level benefits to such a large group of legislators violates constitutional limits on the size of the Council of Ministers and also amounts to an office of profit which lawmakers are barred from holding. He told the court that this practice effectively expands the government through the back door and undermines constitutional checks and balances. The High Court raised serious question over the necessity of granting cabinet status on such a scale and issued notice to the government for a detailed response. The case now stands as a critical test of legality, political accountability, and the boundaries of executive power. More updates will follow soon. Thank you. Jai Hind.